Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott briefing, the Pregnant Workers Fairness Act, EEOC issues final rules. This webinar will be recorded. I want to address some preliminary items before we start briefing. Currently, all listeners' phones are muted. At any point during the presentation, please feel free to submit questions. We will try to answer them time permitting. Today's webinar will be a discussion about EEOC's final Pregnant Workers Fairness Act regulations that were republished in the Federal Register on April 19th and will become effective on June 18th. Today's presenters are FortneyScott attorneys Leslie Silverman and Nita Beecher. I will now turn the program over to Nita.
Thank you so much, Valerie. It's so delightful to be here. Leslie and I have both slogged our way through these regulations, so we'll see what we can do to get you guys up to date. Leslie, I am delighted to have you join us with this webinar. Leslie, having been both an EEOC commissioner as well as a vice chair of the EEOC in the Bush II administration. So happy to have you with us, Leslie.
Thank you, Nita and Valerie. It is a mouthful, Pregnant Workers Fairness Act. So I can see we're going to refer to it a lot as the PWFA, just to be clear. But that is what we're going to be talking about today. That and the regulations. Again,
Indeed.
Great to be here.
All right, so let's go to the next slide really quickly. This is just information which many of you already know, that FortneyScott is a women-owned Washington, D.C. law firm, and basically all we do is agency work. And so we do lots and lots of that, do we not, Leslie? Especially
Oh, we
EEOC.
do investigations and lots of things around agency work as well. But yes, we deal especially with the anti-discrimination laws is one of our sweet spots. So that's why one of the reasons we're here today.
Correct. So let's turn to today's, and of course we have to give the important legal notice. If you are our clients, which of course we hope you were, this webinar is not intended to provide legal advice. If you have any questions, reach out to your counsel, including us, if we are your counsel. Okay, let's get started on what we're going to talk about. All right, Leslie, we just decided to do this. Normally our agenda is kind of short, but we wanted to kind of talk about how we're going to talk about the act itself and what it's really trying to do. Leslie's going to lead on that. Then we're going to work our way through the various important aspects of this. What does it cover? What kinds of reasonable accommodations are you required to do? The interactive process. These things are not entirely the same as the ADA. Some examples, some things that the EEOC is going to say you should always provide and are never an undue hardship. Restriction, here's another big one, restrictions on supporting documentation, which I think is a really big one we're going to focus on. And one of the biggest changes is while they have the ADA qualified definition, they also have as well that you can remove some essential functions and a person is still qualified. Then we'll get into undue hardship and the prohibited employment practices. And finally, we're going to talk about what we think you need to do now. And Leslie's going to conclude with some thoughts about the litigation that's out there challenging these regulations already. And with that, let's kick it off. All right, Leslie, what are we talking about when we talk about the Pregnant Worker Fairness Act?
I just want to observe that first picture. I think that's pretty cool that they were probably hanging outside the Capitol when this was voted on. Well, first, moving to the next slide. Let's just explain that we are going to be focused on the new regulations today, but it's important to realize what things come from the statute, what things come from the regulation, and why we have this to begin with, because we already had Title VII, which was amended by the Pregnancy Discrimination Act. We have the Pump Act, we have well, not under EEOC, we have the Family Medical Leave Act. But the issue and the main purpose of this new statute, it's intended to provide accommodation to enable both applicants and employees who are experiencing pregnancy, childbirth, and related medical conditions to be able to continue to work. It's there to fill in the gaps, and there are gaps because you can get leave or time off for a doctor's appointment under the Family Medical Leave Act. You've got the Pump Act, but that doesn't apply to everybody. You've got other things as well, like, of course, the ADA, but not all pregnancy conditions are going to qualify somebody for an accommodation under the ADA. Congress recognized this and worked on it. It was a bipartisan effort, and it passed Congress in 2022. It was signed by President Biden on December 29th, 2022, and it became effective on June 27th of last year. I would also add, so let's go to the next slide, and we can go from there. So what does the PWFA require? And I think, Nita, you've covered some of this, but I think this is important to emphasize sort of as an overview, because we're going to talk about some terms, some of which you've seen before, and they mean the same thing, some mean slightly different things, some mean completely different things. And so these are what we're going to be talking about today. So covered entity is the same as it is under Title VII. It's an employer with 15 or more employees, or an applicant for an employer with 15 or more employees that's applying to a covered entity. It could also be a union and employment agency. Reasonable accommodations is the same term as used under other laws, specifically the ADA, but it's different. It's different than under the ADA to some extent, and it's certainly different from under Title VII. Known limitations, this is a new term, and that's the thing. We are not talking about disability. A known limitation doesn't nearly have to be a disability. As Nita already talked about, related to pregnancy, childbirth, or related medical conditions, that's a term that goes back years, 40 years. They amended Title VII to include that. And then finally, I want to say qualified, as Nita mentioned, that was what you mentioned, that qualified has a whole new definition. Lastly, we got undue hardship. I didn't even underline it. That doesn't mean it's not important. It is important because a lot of things are going to come down to an undue hardship showing, because pretty much everybody is qualified. I didn't mean to give it away, but so moving to the next slide. So EEOC was charged with issuing final rules. Nita's going to talk about those. But before EEOC even started on that, they were already having to accept charges last June. And I think there was something like 800 charges filed in the 3 months between when the law went into effect and the end of EEOC's fiscal 2023 year. So what EEOC is up to is a big deal. And to that, I turn it to you, Nita.
Okay. And that's a really good point. So I just want to underline two things, a couple of things that Leslie pointed out. You can't really look at the PWFA without taking into account Title VII, the Pregnancy Discrimination Act, and the ADA. Those all have terms and conditions that are related to what we're dealing with. And there's two important things. One, the PWFA, like Title VII, applies to any employer with 15 or more employees. Okay, fine. And unlike the FMLA, no time in service is necessary. So the day that somebody becomes your employee or an applicant, you're covered by the PWFA. And another interesting thing, which Leslie, I think you'll probably comment on as well, is generally, in almost every case, EEOC issues guidance. They do not issue regulations. In this one case, Congress asked EEOC or gave EEOC the authority to do rulemaking like other agencies do.
Yeah, I mean, they have been given permission, rulemaking authority sometimes, but they don't have it under Title VII for substantive issues. So that is why you see so much guidance under Title VII and not regulations. I'm not sure they're going to be willing to provide EEOC regulatory authority in the future, some members of Congress, but this is a pretty long rule, as Nita mentioned. It's 408 pages, and we read it so you don't have to.
That's right. Oh, you may want to when it's all said and done.
You should. Yeah, certainly the
So,
interpretive guidance.
yeah, so the important dates are it was published in the Federal Register on April 19th. It goes into effect on June 18th, which is sneaking right up on us. I mean, we're here at Memorial Day weekend already. And I think there are lots of concepts here that you're going to see that are familiar from Title VII and so forth. And some of the things just to keep in mind are things that we aren't going to cover everything, but remember, confidentiality of medical information is still just as it is for the ADA. And we're going to talk a little bit about prohibitions on retaliation and coercion, along with some of the new prohibited employment actions that'll be involved. Okay, let's get started on the details here. All right, first and foremost, and I think Leslie, you're going to have a comment about one of the EEOC's commissioners' response to this, but this is incredibly broad. So it covers pregnancy, childbirth, or related medical conditions. I mean, I think pregnancy and childbirth is pretty straightforward, but related medical conditions, as defined in the rule, covers just about everything you can think of. And not only that, and I think more importantly, if you have something that is made worse by pregnancy, let's say you have migraines or you have sciatica or you have, any of those kinds of things that are made worse by your pregnancy or by childbirth, or another important one, postpartum depression, psychosis. There's just a huge list. And I think the other thing, Leslie, that is important is it's not just employees and applicants, but it's also former employees, which I thought was interesting.
Absolutely. And what you alluded to is that when the EEOC voted on this, following the vote, one of the commissioners, the two Republican commissioners, voted against these new regulations. And one of them, Andrea Lucas, issued a long statement, and she said that she thinks that the PWFA itself is wonderful. It's a great accomplishment, but she believes that the regulations went too far because she feels that they cover almost every aspect of being a woman, and she particularly has an issue with the fact that it covers accommodations for abortion. Now, I will say that the EEOC has always viewed, and since the law was amended, pregnancy, childbirth, and related medical conditions to include a lot, but there was never a right to an accommodation for it. There just wasn't a discrimination, component. So, anyway, and it always included abortion as part of those.
Well, and the list, as this is just a tiny part of the list goes on for several pages and it's non-exhaustive. So keep that in mind as you move forward. All right, Leslie. So when does an employer know that they have to provide a reasonable accommodation to someone under these circumstances? Next slide.
Okay, so first let's talk about what the new regs say about what an employee has to do to ask for a reasonable accommodation, or an adjustment or a change due to a limitation under the FWA. It's relatively simple, actually. The employee does not have to use any magic words. They don't have to say reasonable accommodation. They don't have to say limitation or anything like that. What they have to do to have this obligation kick in is just let it be known that it communicated to the employer. And the limitation doesn't have to be a disability or an impairment. It simply has to be a physical or mental condition related to, affected by, or arising out of pregnancy or childbirth. So, for example, if an employee says that they're having trouble making it to work on time because they can't hop on the metro or jump in their car to go to work because they have terrible morning sickness, and so they're coming in late, that is enough to trigger an accommodation under a request for accommodation under the act, because they are letting the employer know that they have a limitation and it becomes known. If there's nothing else you take away from what we say today, remember the following two things. One, this is a change. So HR and managers, as we're going to talk about later, need to be trained to recognize that, you know, these type of comments. A lot of places, including the commission itself, put all reasonable accommodations to HR and don't, you know, necessarily let managers deal with it. But if your managers can't recognize it, and it can be difficult here, that is a problem because employers are obligated to act. And two, they're not just obligated to act, they're obligated to act fast. So don't delay. Provide an interim accommodation to the employee while you work it out. Under these regulations, an employer can violate the law simply by failing to act quickly enough to resolve the issue, even temporarily, till it figures things out. And lastly, while on the slide, I want to mention that when must an employer provide a reasonable accommodation? On that the PWFA is about providing accommodations to the employee and only the employee. So someone else may contact the employer on the employee's behalf, their husband, their mother, to communicate an issue the employee is having, but there's no right of associational accommodation under the PWFA, just like there's no right under the ADA. So moving to the next slide. Once the employee does request accommodation, the employers must engage in the interactive process. Now, that whole process can be fairly simple and straightforward. It can consist of a very quick discussion, a text, an email exchange, a phone call. I need to drink water throughout the day, so I need to keep it at my station. I'll keep it on the floor so it doesn't spill on this assembly line. Okay, that's just fine. Now, it wouldn't hurt the employer to say, is there anything else you need? But that could be enough. But there'll also be times where an employee's request will require more interacting. And that happens when the limitation is not clear, or it's unclear what type of accommodation the employee is requesting. And in that case, the employer has to engage in the interactive process with the employee to figure it all out, so that the employer can understand what the employee needs or what the accommodation should look at. Now, even with the PWFA, which I would say, and I think Nita, you'd probably agree, is the most employee-friendly civil rights law ever enacted, the EEOC has stated that the employer should consider the employee's preference for the obligation, but at the end of the day, it's the employer's final choice. So as long as it alleviates the issue and allows the employee to continue to work if they want to, that is enough. Okay,
Well, and
so
yeah, and that's exactly right. So let's talk about some of the kinds of reasonable accommodations at the EEOC in the next slide. So this is a list of just examples of reasonable accommodations, you know, breaks, to drink, to eat, to rest, to use the restroom. And Leslie and I both have children, so we know what it's like to have that baby sitting on that bladder every day, all day long for months. You know, changes to equipment. There's an example. By the way, after the regulations, there's this wonderful interpretive guidance that the EEOC provided, which we're quoting from in some cases, which says all kinds of different ways that somebody can ask for accommodations and what's acceptable. And one of them is you're 7 months pregnant and you can't get in your safety equipment anymore. They have to get you new safety equipment, for example. Work schedule, shorter hours, later start time. Leslie mentioned morning sickness, paid time off. Now, this is an important one. We're going to talk about, I want to talk about leave a little bit differently here in a minute. But for example, going to medical appointments, providing accommodations so you can go to a medical appointment and to recover from childbirth or related medical conditions. And finally, we're going to We're going to wait just a minute to talk about essential functions because that is the biggest change and the most controversial, other than abortion, obviously. And I think going to be the trickiest, to be honest, for employers. And we'll talk about that in a minute. But I want to go back and talk just a minute about leave. So remember what Leslie said at the beginning, which is the reason for this law is there was a hole and women basically had to gut it out or else quit or go on leave when they were pregnant. And now there is a law that says we want to keep you in the workplace to the extent that's reasonably possible with accommodations up to the point where it becomes an undue hardship. So leave in and of itself can be a reasonable accommodation. For example, is here doctor's appointments, after childbirth, and so forth. And you may need to provide leave in certain cases, but you can't make somebody go out on leave when you have a reasonable accommodation that would keep them that would keep them on the job, because that's the whole point. Leslie?
If it's their preference, then the law
Correct.
is, you know, so they're not going to keep them against the employee's will if that is what they prefer. But often employees felt pushed out
One other thing I
during.
just want to mention, which it's like in this situation, it's like FMLA. When they go out on leave under the PWFA, they get to come back to their job. No one's really talked about that, but that's hidden in there and something to keep in mind. So let's go to the next slide to talk about. So this slide was probably the hardest one because it covers, it falls in a couple of different places. So there are 4 accommodations that EEOC is almost always going to find are not an undue hardship. So if an employer wants to claim that doing any of these is an undue hardship, they are going to be pushing a rock up a hill in a big way. So they are the ones Leslie mentioned. You've got carry or keep water near or be able to drink it, you know, because sometimes you can't do that. To take additional restroom breaks, exactly. Stand if you normally sit, and sit if you normally stand. Think about, you know, the women at the registers in the grocery store, places like that. And taking breaks. A perfect example, there was one example in the what we were talking about in the interpretive guidance that talks about a woman who's got diabetes, and because she's pregnant, it's worse. So she has to have more breaks to eat to keep her diabetes under control. Again, she actually has a disability. In that situation, she has 2 reasonable accommodations. She's got an accommodation for her disability to take breaks and eat, and then an additional one because she's pregnant. And I think these 4 should be no-brainers for managers and HR. And we'll talk a little bit about some of the issues you're going to have to deal with managers, because there's a reason why people are pouring in to file charges with the EEOC, because I think a lot of employers are not ready for this, you know, which has been in effect for a year already. All right, so we talked a little bit about accommodations. So let's talk about documentation. Documentation, Leslie.
So we actually have 2 slides on documentation, which you'd think, well, why would you need that? But I have to say, they're kind of a big deal, and you'll see that it's a change from what an employer can and usually does request under the ADA. That's one of the reasons it's a big deal. And the differences between the two and the consequences for employers who run afoul of these changes and adhere to an ADA-like process is stressed repeatedly. It's stressed repeatedly in the regulations and interpretive guidance, and when the EEOC talks about these new regulations. So we really want you to understand what it says. So our employers are limited on what they can request in terms of supporting documentation, on when they can request supporting documentation under the PWFA regs. The request must be quote unquote reasonable under the circumstances. And a request for documentation is not going to be considered reasonable in any of these circumstances, when it's obvious, when it's already known, when the accommodation is predictable, so there's no reason you have to ask for it. if the employee is asking for something that normally wouldn't require documentation, making them go through a formal process is a no-no. And obviously, also pumping or nursing during working hours also would be considered. Next slide.
Leslie, as you go to the next slide, I did see something from the EEOC saying you cannot require your employees to use the ADA or FMLA forms that
Right.
for purposes of this.
Right, I was getting to that. But so an employer can ask for paperwork to support a request where the need for the accommodation or the accommodation itself is not like typical or apparent, but that documentation request itself has to be limited. It has to be limited to confirming a limitation which is not apparent, or to confirming that it's not confirming that it is related to pregnancy, childbirth, or related medical condition. It must be limited, directly related to the specific claim condition. This is not a chance to find out everything about your employee's medical health. It has to be limited to, if need be, to describing the potential accommodations that will alleviate the issue if those aren't really apparent. And another thing to keep in mind with this, an employer cannot require a second opinion here. So the key takeaways: paperwork is limited. Do not use your ADA form. You can create a new form for limited circumstances where paperwork is required. But if the employee does not fill out that form, don't adhere to that, because you can't, that alone could be a violation. And do not delay the accommodation while you're waiting for the form. Yeah, figure something out.
I had a couple of others. They have something, Leslie, what about this self-confirmation? That's a new aspect that you can self-confirm, I'm pregnant and I need not to be able to lift or something like that.
Right, I don't think you have to present a pregnancy test, and like, which would
Correct.
be,
That was an example. That was one of the examples. You can't make
right.
them go and present
I
a
mean,
pregnancy test.
I'm sure there are situations where people have faked pregnancy in life, but don't question them in this circumstance, because unless you have some really good proof that they're doing
They did
something nefarious.
yesterday. I saw one EEOC webinar. We always like to make sure, we're kind of in sync with what they're thinking. And they made the point that you can ask for documentation. For example, if an employee wants a full remote job because they are nursing and can't pump at work for some reason. I mean, the situation like that, that's different. I think that's that higher level where you can. But I think your point is generally don't ask for it unless you really need it.
Yeah. Treat these employees, especially the ones that are obviously pregnant or have just come back from leave, when, like in your most favored nation status. I mean, think about how much the world has changed since even when we were pregnant. If you go to the store, there's parking spaces for employees that are pregnant, and now they just want to see this in the office. They want employees to be able to get these because it's common sense sometimes, except for
Yes.
when it's not.
Well, and one last thing, you made the point that you can't ask for a second opinion. You also can't make them go and see your doctor, the employer doctor as well.
Right.
So, all right,
That's
now
true.
we're about to get into the really fun part, right, Leslie? Are we ready?
Yeah,
Okay, here we
yeah.
go.
I'm
All
glad
right.
it's your slide, Nita.
Well, I'm going to let you jump in too as well. Okay, so qualified. We all know that under the ADA, a qualified individual is an employee or an applicant who can perform the essential functions of the job with or without a reasonable accommodation. Now, that essential functions is going to become a huge question moving forward in this. All right. Now, under the PWFA, not only do you have this definition like the ADA, you have a different definition that an employee who can't do one or more essential functions can still be qualified under the PWFA, i.e., can still be qualified with or without an accommodation, provided the inability to do that essential function, like lifting, let's say, is for a temporary period, which is not defined, by the way, that the essential function could be performed by this employer or applicant in the near future, i.e., after pregnancy, and that the inability to perform can be reasonably accommodated. I suspect that last one may be the one where employers are going to possibly have opportunities for, undue hardship. But, the whole idea again is try to keep them at work as much as possible.
Sure, these are all very difficult terms to understand, and this is where we're going to see, I think, a lot of litigation and confusion for employers. And I'd say some of the documents the EEOC released were helpful, but honestly, Nita, I think I don't recall seeing any examples where an employee wasn't ultimately qualified. They are just not going to fall out if they, of
Correct.
the job as not qualified in most instances.
Well, even where they found that there was an undue hardship, they say, well, you said you could do 6 weeks, but you can't do 8 weeks. We'll give them 6 weeks. So we'll talk about that in a
Right.
minute. But
Yeah,
this,
but it's not underqualified, whereas
nope.
before we would say they fell out underqualified under the ADA. So this is a big difference between how the law is applied versus the ADA.
All right. So let's go to the next slide, because what does temporary mean? Well, temporary means the inability to perform for a limited time, not permanent, and may extend into the near future. What the heck does that mean? And that's exactly what's in the regulation. And it's what they, as Leslie just said, there's really no additional information there. All that they said was temporary is not indefinite. So there potentially is an end at some point. But I think the most important thing to think about as we talk about how long you have to have these temporary, you suspend, but let's call it suspend your essential functions. So for pregnancy, it's up to 40 weeks, which is the length of time, obviously, for a normal pregnancy. In the proposed rule, they were saying 40 weeks after childbirth. EEOC has backed off of that, and they basically have said it's going to be on a case-by-case basis, which means you're going to have to figure it out each and every time, because these people go out on leave, they're allowed to come back to their job, and then you figure out what, if any, essential functions are they temporarily not going to be able. A perfect example, I had a C-section with my first son. And for example, for women who have C-sections, let's say they have to be out for 8 weeks because they can't come, you can't drive, you can't go downstairs, and a bunch of other stuff. Or you have 2 or 3 months after you had your C-section, you can't lift because of you had, surgery. So those are areas where it's going to really be the particular job, the particular person, exactly what their medical situation is, that you're going to have to take it a step-by-step process.
Yeah, I mean, all I'll add is it made it case by case, the change from the notice of proposed rulemaking to the actual final rule. But and some of the examples were far less than 40 weeks. But there's an
Right.
example and that makes sense, but for pumping, and it was I think a year and a half later.
Right.
So I think the commission has left wiggle room, which we understand, but that also causes uncertainty for employers,
Right.
especially because of the broad nature of related to pregnancy and what that could include. So
Well, and let's talk just a couple of things. So
childbirth, sorry. Yeah.
right, exactly. So the clock, so as we said, you've got your pregnancy 40 weeks. It restarts when they come back from childbirth. And so it's reassessed at that point on that case by case basis as to whether or not they can perform the essential functions. And you may have different. So you have one set of essential functions that have to be removed while you're pregnant, and maybe a different set that have to be removed, after you have the child for different reasons. And so that's something you're just going to have to work through. One other thing that I wanted to mention is that Carol, I can't, Mozkov.
Mioskov. She's the legal counsel at the EEOC, which is the department at EEOC, which is responsible for writing the regulations and guidance.
She did a webinar, and one of the things she talked about is a requirement to do job modifications under here, which could be a reasonable accommodation for this temporary suspension of essential functions. You know, that they continue doing the rest of the functions, that they do the rest of the functions plus new functions that the employer gives them. They perform a different job. You move in that one of, at the Institute meeting last week, one of our members said, we just try to find another job for them, you know, that they can do, or that they be assigned to light duty or modified duty. So those are some of the things to think about, you know, as you're trying to figure this out. And it's going to be, I think, a big deal.
Okay. So moving to the next slide. Okay, so undue hardship. The parts of the undue hardship are very, again, similar to the ADA. The regulations state that it's a significant difficulty or expense incurred by the covered entity, the employer, in providing the reasonable accommodation. And to figure that out, you need to focus on the resources and the circumstances of the employer in relationship to the cost and difficulty of providing the accommodation. So it's really going to depend on the size and resources of the employer, how many other employees are there, and safety related issues and need to have, people doing functions as you're trying to determine if it's an undue hardship. But there's an added component here because, of course, under the ADA, we can move to the next slide. If you remove an essential function, it was the person was not qualified. Next slide, please, Valerie. Thanks. But there's also a part of this, it's a departure, as I said. So because it does allow under the PWFA for a temporary suspension of essential function as a reasonable accommodation, you have to consider that when you're deciding what would constitute an undue hardship. So EEOC in the regulations provides a second list of factors that should be considered. And not one of these is dispositive. So it includes the length of time the employee will be unable to perform the essential function. And let me add here that you cannot include the time that they're going to take off for maternity leave when the employee is pregnant, or the time that they took off of maternity leave or pre-pregnancy when you're looking at when they return to work, which is not very, I understand why they did it, but it's just not very practical because you could be talking about months and months, but you have to look at it separately. So whether there would be other work for the employee to accomplish, this is huge. I mean, you can remove more than 2 essential functions, that's what the EEOC says, but if there's ultimately no job for that employee left to perform, then that could be an undue hardship. And then, you have to look at things like the nature and the frequency of the function. How often does it have to be performed? Whether it's been suspended for other employees, whether other employees or temporary employees or third parties could perform the essential function, even if they have to be hired. And that, of course, depends on the resources of the employer. And whether it could be postponed or suspended for a period of time. Sometimes things don't have to happen during a particular period. It's your job duty, but it's not tax time. Whatever it is,
Right.
that's also what they're looking at. The interpretive guidance provides several examples of when an accommodation could be an undue hardship that I kind of wanted to mention just to give you an idea. And one example, a convenience store employee, they're getting to that point, it's like the last 3 months of their pregnancy, and they said due to exhaustion they want a part-time schedule, but it's a small store and they need 2 people on the floor for safety and other reasons, and because of the suddenness of the request, they don't have the time or the ability. So the commission says providing the accommodation could be an undue hardship. A second example is the EEOC says that, a dental hygienist who wants to work from home and do paperwork as an accommodation if there's only one other hygienist and you need two of them there to make the practice work, that could also be an undue hardship. But in each instance, and this is another really important takeaway, the EEOC makes clear that the employer must offer the employee other reasonable accommodations. They're not going to solve all the problems in this case, but providing a stool and rest breaks for the convenience store employee throughout the shift, if that's not going to cause an undue hardship, or, for example, maybe scheduling the hygienist less frequently, or allowing rest between patients. So if the employer just says no, that's a problem. And it's important to note here that the accommodations EEOC lists as predictable assessments, as Nita said, will almost always, if you deny those will almost always cause an undue hardship. One last issue, and I think you may have mentioned it, Nita, but if it's a temporary suspension of an essential function, and you say, well, it's a 4 months that they need this accommodation, and we could like live with 2 months, but the second 2 months are a problem, you have to accommodate the employee on the job for the first 2 months. And the second 2 months, you have to see if there's another accommodation. So those are all things to keep in mind when you look at undue hardship under this new law and regulations.
And Leslie, one other thing, listening, so the EEOC webinar I listened to yesterday was focused on workers. So that was a really interesting approach. So it's sort of, this is what they're telling workers, which is the other reason I think we're seeing this huge influx of charges, because EEOC is out there telling people about these rights. But they also pointed out that if your employer says it's an undue hardship to do whatever to give you a reasonable accommodation, you have a right to ask them, what is the undue hardship? Why did you, what's the reason you're not granting this? And I'm assuming the next stop they will go to will be a local EEOC to file their charge. Or
unless you
online,
have a very good
these days.
answer for them and you've
Correct.
documented it, but we're
Correct.
jumping ahead.
And
All
you
right.
did the interactive process.
Yes. And you always have to do that. Okay, let's go to the next slide. So there are aspects, and this is in the statute itself, and of course discussed in the regulations, that are always considered 5 employment practices that are prohibited under the new law. So one's failing to provide a reasonable accommodation. I think we probably made that pretty clear at this point. Requiring a qualified employee to accept an accommodation other than one that is arrived at through the interactive process. So of course you don't have to pick the one the employee wants you to pick, but you got to go through the interactive process, a back and forth to get there. Denying a qualified applicant or employee an employment opportunity because of a reasonable accommodation. Of course, requiring leave as a reasonable accommodation where there is another reasonable accommodation available that the employer could provide, but again, requiring, and retaliation, taking an adverse action against an employee. So again, an employer, you cannot ignore or simply turn down a covered employee's request for accommodation. Second, while we said, I already discussed this, it doesn't have to be the specific accommodation, but you really have to go through the interactive process. Forcing leave, never permitted. So employers need to be mindful that if they deny an employee a promotion or another opportunity, such as a training program, simply because the employee is pregnant and will be taking maternity leave, or recently had a baby and needs to take breaks for pumping, absent undue hardship, they're likely to run afoul of the PWFA. Lastly, this statute contains very broad anti-retaliation provision, and it includes things like if you penalize an employee for requesting or using an accommodation that has been granted previously, that's a sure violation. If you penalize an employee who doesn't meet a production standard, such as a sales quota, because of an accommodation, you're also going to run afoul of the law. But that doesn't mean you can't have a sales quota. It just means that quota has to likely be prorated. So hopefully
Yeah,
this gives you a little bit more of an idea of what is required under this statute.
they specifically on that thing, that particular point about the policies and productivities and so forth, you know, if you are going to the bathroom all the time, you're not going to meet the same standard probably that the people that aren't going to the bathroom all the time or taking breaks or eating or whatever needs to be done. And so
Right.
the employer has got to figure out how not to penalize them at work. And there's an example of a woman being given, you know, a PIP or a, you know, she's being given discipline because she didn't meet the standard because she was going, you know, she had an accommodation. And I think that is a really big point, and a lot of employers may not have thought about it, and how important that is.
Absolutely. Okay, next slide.
All right, now we're ready to talk a little bit about what we think employers should do. And I love this particular picture. They used a lot of these pictures on the slides that they had yesterday as well. There is no posting requirement that I could find, but this was a poster that's used in healthcare on the PWFA, and I think it's a very effective one if you don't have one. All right, let's go to the next slide. You know, I think, Leslie, as we walk away from what is required, I think the most important thing to keep in mind is to know what your essential functions are. Because as under the ADA, if you don't identify an essential function, then you have to accommodate them, you know, an individual. We do have this situation where certain essential functions can be removed, but if you don't know if you, the employer, don't know what the essential functions are for these various jobs, you're going to have a hard time arguing that the employee is not qualified without having to be, you know, without having to have some of those essential functions taken away. Most of the examples in the interpretive guidance are around lifting, being around chemicals, standing or sitting, you know, for long periods of times. Those were a lot of the examples of things that were taken away from the position. The other thing, last week or 2 weeks ago, actually, at the Institute meeting, we had a couple of members talk about what they're doing with their accommodation process. And I think number one, most people, if they don't already have their accommodation process centralized, they are centralizing it for purposes of the PWFA. And of course, there's also an interrelationship between ADA accommodations and PWFA accommodations. You may have both, or you may end up with one afterwards. And so it's necessary that there be consistency across the organization. But Leslie, you made a really important point. You got to train your managers as well. The managers need to know what it is they should look for when an accommodation has been requested, which is going to be, you know, my stomach's really upset and I need to be able to go to the bathroom whenever, or, you know, we have a number of those kinds of examples. And I think it's important to figure out the process you have now for ADA and how it needs to be different for the PWFA, many of the things we've already talked about. And I think you've got to make those changes now because, Leslie, go ahead.
I'm going to add, not only do you want to train your managers to to be able to spot it and get it to the centralized process, but even if they've ended up doing it informally, you want to know about it so you can
Yes.
document that it happened, because later on when you're accused of not helping the employee when you actually did, you know, it's very important to just educate them so
Right.
that they can let you know what's going on the floor.
Well, exactly, because, you know, if they give, and this even happens under ADA, people, you know, a lot of employers early on said, well, you know, we're gonna accommodate, and you don't document it, then, you know, you don't know, and you get a new supervisor who doesn't want to do that, you have no documentation about what was done before. So that's really important. Um, as Leslie talked about, the new documentation parameters for the PWFA are very limiting compared to what you're used to for ADA and other leave requirements. So you really need to keep that in mind. and figure out how, I mean, what kind of form do you want, if any? If nothing else, if you get a contact between an employee or an applicant and one of your managers, you want something they can fill out and send to whoever the right person is and say, I got this request from XYZ, pregnant, they need not to be around chemicals or whatever the point is. We talked about essential functions, but I can't reiterate that enough, that you need to know what they are so that you know whether you can live without making those changes. Can you live without having those essential functions done by that person? And one of our members said they basically start looking, if they're, depending on what the essential functions are that need to be removed, they're going to have a process to try and help the person find another job for some period of time. But it's a large employer. Not everybody can do that. But it's an employer that has a lot of physical jobs. So they do need to be able to move people around, even under light duty, for example. And then we just talked about the workplace rules, whether it's, having people wear those little, so they know how much time you're actually spending, lifting boxes or whatever it is you do, the productivity kinds of things. You need to really look at that and see how are you going to handle when someone has an accommodation and they're going to not meet the standard based on the fact that they're not full-time working there in the bathroom or they're taking a break or whatever because of the accommodation. One other issue that was brought up by a member is, a lot of people have third-party leave managers. They have like a vendor that handles their leaves. How are you going to do that? One of the members said they're going to have a internal, so the leave manager will look at the request, but before it's finally approved, it's going to come back into the company and they'll have an oversight to make sure that it's consistent and that it's, I mean, because what Leslie said, pretty much you're supposed to accommodate everybody. And so they want to make sure that that's being done, or if leave is being requested, it's being done properly. And honestly, I can't say this enough. Training, training, training.
Yeah, and again, with all things with third-party vendors, do not rely on the third-party vendor for your defense, because
Right.
it's not an excuse with any of the anti-discrimination laws at the end of the day.
Correct.
That doesn't mean you can't have, I mean, a lot of third-party vendors are very well trained in this and they know what to look for because it's what they do. But just, rely but verify.
Correct.
Have a new system in place.
So Leslie, you want to do our last, we're starting to run out of time, but we got a few minutes to talk about
Yeah.
where we are.
Okay, so everything we said doesn't matter because it's going on. No, I'm just kidding. That's definitely not true. But there are some challenges in the courts to the PWFA, the statute itself, and the new regulations that we wanted to make you aware of. For the most part, right now, these cases all involve states complaining about the statute as it applies mostly to state employees. But some of the theories could be used potentially by private employers, possibly. First, we wanted to mention the statute itself. Pretty soon after the PWFA was enacted, there was a challenge in a federal district court. This was in Texas. This was the Texas Attorney General. And what happened is that the Texas Attorney General said that the PWFA was unconstitutional in the way it was enacted because the House of Representatives lacked a proper quorum when it passed the PWFA back in 2022. And the reason that it said that is because there were different rules in effect at that point in time that were in effect because of COVID for proxy. And so as a result of that claim, they said it was unconstitutionally being applied to Texas state employees because Texas had to expend money training the employees and changing their rules, and they shouldn't have to spend that money. The law was enjoined in a very narrow way in that EEOC cannot enforce the law on behalf of Texas against Texas on behalf of Texas state employees. So that is being appealed. EEOC is appealing that ruling, but we're all waiting to see if there will be exact copycat claims against the PWFA, the statute, or what else we'll see. In the meanwhile, it's no surprise that the regulations included abortion. That was in the notice of proposed rulemaking, and so it has drawn the ire of a lot of other state attorney generals as well as members of Congress. And so we're going to see challenges, and we have seen challenges to the regulations itself. We have 17 attorney generals who filed the lawsuit. It's being brought by the Tennessee Attorney General, but it's being brought, interestingly, in Arkansas on behalf of the 17 AGs, and they're arguing that the new regulations are unconstitutional and that they violate the Administrative Procedures Act because they extend PWFA's accommodations to abortions, which are illegal in different ways under their various state laws. Now, on Friday, EEOC urged the court not to block these final regulations, arguing that these concerns are merely hypothetical because they haven't shown that the regulation will impose any real injury upon the state's abilities to evaluate abortion. So the Supreme Court usually says hypothetical. This standard is very hard to enforce, but we don't know what will happen. EEOC made a lot of other arguments, some of which we've talked about, that these conditions have already been covered under Title VII, and various arguments like that. And we'll just have to wait and see what happens in the courts. In addition, a suit was filed in May in Louisiana and Missouri, your home state, Nita, alleging that regulating abortion violates the sovereignty of the state and could cause irreparable harm. So that second suit was filed, I think, in May, and we're going to just have to wait and see what happens with that. We may see more challenges, but as of right now, I would be complying and getting ready for the PWFA and the regulations to become effective. The PWFA are already in effect.
Well, Leslie, we're almost out of time. So let's just go to one last slide and just say, do you have one takeaway that we can do in like 1 minute to pass on to our audience here?
One takeaway. Well, I think I've said my takeaways, but I will say I just think training and realizing this is not the ADA, and we just have to look at this law a lot differently and be aware as we move forward. Treat employees as the most favored nation status, because we're a far cry from where we were when you would tell your employer you were pregnant and get fired way back when, thank goodness. But these are going to be some challenges for employers.
Right. I think that's right. And I think everybody needs to really understand every aspect of this new law and how it is different from the ADA, because that is going to be very confusing, not only to employees and applicants, but also to the employers. Well, with that, I think we're done. If there are any questions, feel free to email both either Leslie or I. I think we're out of time to actually take those right now. But Valerie, can you close us out?
We would like to thank you for joining us. And if you have any further questions regarding this topic, please email us at info@FortneyScott.com. And also, for more information about this and other important topics, please listen and subscribe to FortneyScott's DC Insider Employer Update podcast, which you can find on FortneyScott.com or anywhere you listen to your podcasts. Thank you.
Thank you, everyone, for joining.
Thanks for coming.